Can a trust protect client assets from divorce proceedings? Imagine having a safety net that could shield some of your assets if your marriage hits rough waters. That's what trust planning can sometimes do, but it's not a simple yes or no answer. Trusts are legal arrangements where a person called the grantor moves assets to a trustee, who manages them for one or more beneficiaries. They are often used in estate planning to control how assets are distributed and to provide some protection. But whether a trust can keep assets safe during divorce depends on many factors. First, courts look at whether assets in a trust are considered marital property or separate property. Marital property is divided during divorce, while separate property is not. The timing of the trust's creation matters a lot. If a trust was set up before marriage and funded with assets that were not part of the marriage, those assets are more likely to stay separate. If the trust was created during the marriage or funded with marital assets, courts might see those assets as part of the marital estate. There are two main types of trusts: revocable and irrevocable. A revocable trust, also called a living trust, can be changed or canceled by the grantor at any time. Because the grantor controls the assets in a revocable trust, courts usually treat those assets as part of the marital property if they were funded with marital funds or created during the marriage. This means they can be divided in a divorce. An irrevocable trust cannot be changed once it is set up. Assets placed in an irrevocable trust are generally considered separate property, especially if the trust was funded with assets that were not marital property and the grantor does not control the trust. In many cases, assets in an irrevocable trust are protected from division during divorce. But this is not a guarantee. Courts can still consider the trust if it benefits one spouse or if the assets have been used for the marriage. Trusts that hold inheritance for a spouse can sometimes be protected from divorce. For example, if a parent creates a trust for their child and the spouse is not a beneficiary, those assets are less likely to be considered marital property. Discretionary trusts, where the trustee controls distributions, and spendthrift trusts, which limit access to trust assets, tend to offer stronger protection. Timing is key. Creating a trust before marriage is usually better for asset protection. If a trust is established during marriage, it's important to fund it with separate assets and avoid mixing those with marital funds. The terms of the trust also matter. Trusts that give the trustee full control over distributions or restrict access can offer more protection. Remember, courts have broad discretion in divorce cases. They may look at how the trust was used, whether assets were hidden, and if the trust benefits one spouse. Even a well-structured trust might be considered if it appears to be a way to shield assets unfairly. In the end, a trust can help protect assets from divorce proceedings, but only if it's set up and funded correctly. Working with legal and financial professionals is essential to make sure the trust aligns with your goals and complies with the law. Proper planning can make a difference in safeguarding your assets for the future.